essential for all the commercial, contractual, I would say that one professionals working within the industry. As you all are aware that the world will not run without contract in terms of executing and delivering any construction aspect. So all the aspects that we are dealing, all the aspects that we are speaking, all the aspects that we are handling, that should have contract. But the other part of that aspect, many of our commercial, contractual professionals, they're not very much aware about certain very simple aspect, very simple fundamental element of a contract. And we all know that when you go and sit down with the contractors, or when you go and sit down with your subcontractor as a main contractors, or when you go and speak with your supplier, or when you do any negotiation, if they are going to use any legal terms, if they are going to use any aspect of a contract, if you don't know about it, of course, you will be humiliated. I have noticed that in many situations, when we speak about contractual aspect, the opponent was not aware about that. And he was unable to answer to us at least in a 1 or 2 line. Yeah. So in my opinion, I would say that the things that we want to know about contracts is very, 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 very minor. We are not going to go and work as a lawyers. We want a knowledge, fundamental knowledge about what is contract and how a contract can be formalized. It's a very simple thing. Only thing that you need to have, you have a courage to learn the things. That's it. Okay. So today we're going to speak about the 10 major aspects of contract. Without these elements, you cannot call anything as a contract. And remember, throughout the session, if you have any questions, please keep that question with you. You can post your questions in the chat. As you all know that one, we don't want to switch on the mic, or we don't want to allow you to switch on the mic throughout the lectures. As we all know that one, what will happen without knowing, unconscious, your mind may switch on that one, and we will hear all your talkings and everything, your family, chit chat, your children's, concerns and everything we will hear. So we don't want to do that. That's why we disabled your cameras and microphone. And if you have questions, you can prepare your question and post your question in the chat. Okay, so remember that. And at the end of the lecture, at the end of the CPD, you will have a small a QR code. You need to scan it if you want CPD record. If you want a CPD certificate, you need to scan that QR code and apply with your names and everything, so you can go ahead. You can do the things. Okay, right. So before we start that, guys, I would like to ask, how many of you are aware you can use the chatter on top of your MS Teams? You can see an option called chat. Okay, if I ask question, I prefer you all to interact with that. Right. When we speak about contracts, guys, how many of you are aware that last year, if you are from GCC, okay, Gulf region, how many of you are aware about the number of or the amount of contract each and every country's signed? How many of you are aware? Anyone knows what is the amount each and every country's, or maybe Qatar, Dubai, Saudi Arabia, they have signed? Asim said not at all. Okay. So before we start to learn what is contract or what are the aspects of contract that we need to learn, I would like to give you a very small information. Okay, very small information, which is about the contract expenditure maps throughout GCC. When you speak about Kuwait, in 2024 only, Kuwait awarded a contract worth of $9.5 billion. Okay, which is last year in 2023, and this year it's 9.5 million. In this year mean 2024, last year report. Okay, and similar to that, Qatar awarded almost 18.9 billion US dollar. Billions, it's not a million. Remember that. Billions worth of contract in 2024. Okay, it's a huge amount of money, not a very simple amount of money that we are thinking. When we speak about Kuwait, last year 9.5, in 2023 6.3. So almost they increased their contract amount by 50% of the previous year expenditure. Similar to that, Qatar, it's very minor increment. And when it comes to UAE, in 2024 only, UAE awarded $81.3 billion worth of contract. These are not very accurate numbers. As much as possible, I collected the information from the relevant authorities. So they got 81.3 billion. They awarded 81.3 billion in contract. And when it comes to Saudi Arabia, of course, most of you might have heard about Saudi Arabia, what they are doing, what they're executing. And last year, 2024, they have awarded $148 billion worth of contracts. So think about the scenario. So all these work that the governments awarded to the peoples, do you think that all these things will be executed by verbal agreement or through WhatsApp or maybe through email? Absolutely not. The money that they are telling, some amount of money is equal to the budget of a countries, of some countries, I would say. Yeah, 148 billion. They awarded a contract for other people to execute and build something which is equal to some countries' budget for that year, or maybe 2-3 years. Right. So it's not a simple matter that we are going to handle. As we all know that you all are commercial peoples, and I keep telling this to my students and many other peoples, right? You are the front line runner. You all know that you are dealing with money. If you don't run the project with the proper manner in terms of bringing money back to the company, you are preparing IPA, you are approving IPC, you are handling the variation, you are handling the changes. So all these are related to money. And all your companies, all the employers, and all of these people are running, constructing, executing, operating for what? To earn money. So at the end, the commercial and the contractual people are the front line runner to bring and execute and ensure that they are properly injecting the required blood to the project. The money is the blood. So think about the amount of money that the countries awarded in terms of contract. So do you think that we need to have a fundamental understanding about the contract, as it's a huge amount of money that we need to handle, or we are going to prospect, or we are going to represent? Of course. Before we dive into the legal aspect of the contract, I would like to very clearly give you a very clear picture about what is agreement, what is an agreement, and what is contract. Most of the time, we don't differentiate, whether it's me or you, whoever it is. We don't differentiate it. We start to talk from our mouth. Oh, right, you know that when the client signed a contract, the client made an agreement. Client signed an agreement. Do you think that all these two are synonyms? Same word with the same, most of the time 100% or 90-95% same meanings? No. When it comes contract, first we need to understand what is agreement. Agreement is, let's say I call one of my friend, a very simple example. I call him shall we go for a coffee tonight? Or shall we go for a dinner tonight? He said, yes. He said, yes. I did not prepare a paper and ask him to sign it. And I just casually asked. He casually said yes. And 6 o'clock, he phoned me and said that one, Asmi, sorry, I'm unable to attend that one. Guys, let's give a minute for that. Thank you for that. So we we took a pause for 1 minute for that. Okay. So I said, I called one of my friends for a dinner and he said, yes, let's go. Afternoon, he said, yes, let's go. Then 6 o'clock, he phoned me and said, no, ask me, I'm unable to attend. Do you think that as we agreed something, right? He agreed to come with me for a dinner. As we agreed something, I'm going to take him to the court and tell the court, dear court, he's my friend. He agreed to come with me for a dinner, but unfortunately, later he phoned me and said that he was unable to attend that. So please, as he breached the contract, please punish him. Am I going to do that? Definitely not. So when we speak about agreement, agreement is just an agreement between two or more parties or two or more people to come to their mutual understanding about their rights and obligation. Right? It's just an understanding, and it's not going to bring you any legal enforcement. If you go to the court will tell you it's just an understanding. There is no confirmation that, or maybe you don't have a proper writings and everything. You don't have a proper explanations of who gives what, who is going to take what. It's very informal. Go home. When it comes contract, the agreement which will be signed by the parties with a certain aspect in it. Right? Did I tell that in the agreement that I asked my friend, please come for so and so thing, dinner. So I will give you 200 riyal. And he accepted. Or maybe my friend requested me something and I accepted on behalf of exchange. We did nothing. Just an agreement, casual agreement. I called him, he said yes. For my offer, I offered something dinner and he said yes. But when it comes contract, remember that contract is not going to be something like a verbal or maybe some kind of very casual thing. Contract can be a verbal. Contract can be a formal. contract should have certain element in it. It cannot be something unwritten. It cannot be something without any element. So you may ask a question. So ask me, is it compulsory to write the contract? It is advisable. So contract means two or more parties making an agreement. And in that agreement, they are going to insert certain essential elements we call offer, acceptance, intention, consideration, legality, freedom to sign, and a couple of other factors. Okay. So this document, which will be signed by the parties, and that will be used as an evidence if you're going to go to the court, where the court will use the document as an evidence that you two parties made a contract. And that contract produced this evidence, this document, which will be used as an evidence in front of the court to punish you or to ask you to do anything that you agreed to do within the document. So remember, agreement is a more formal understanding of the rights and obligations between the parties. Where contracts mean, yes, it is rights and obligations and understanding. Not only that, the parties firmly agreeing and inserting everything required to consider that as a legal document in front of the court. That's what we call contract. So remember, not all the agreements are contract, but all the contracts are an agreement. Remember that. Okay, all the agreements are not contract. Some agreements, friends, me and my friend made an agreement to go for a dinner. Is that the contract? No. But my friend and myself, we made an agreement to start a business. So in that I mentioned that I will give you 10,000 Riyal, and he agreed to put 20,000 Riyal, and we started to do XYZ, and we started to split the benefit by 50-50%. We started to put many things, and we wrote everything and we signed. Or maybe we agreed through verbal and we confirmed that. Then that will become as a contract. Okay, so this is very fundamental understanding. So remember that when you speak about contract and agreement, you must be aware and very much vigilant about what is agreement and what is contract. Okay, right now let's learn some fundamental legal aspect of a contract that you all must be aware about. The very first one, that you must be aware about privity of contract. Privity of contract. In some situation, you and the employer, or maybe the contractor and the employer, sign the contract. For an example, they sign the contract. And have you ever noticed, if you are a consultant or the engineer or the PMC, have you ever noticed that your contract, or maybe have you ever noticed the signature of the engineer in the contract? Where do they sign? Where do they sign? You have an agreement for a project. In that agreement, under what sections or where do the engineer signs? Guys, use the chat to type your answers, please. Okay, only stamp, nowhere. They don't. They are not a party to the contract. Doesn't. No place. No signature. No place. No signature. Engineer cannot sign. Nowhere. All right. Okay, good. So you all know that in a contract, the parties to the contracts are only the contractor and the employer. Then who are we? If you are an engineer or maybe PMC or supervision consultant, who are they? They are the employer's representative. Employer's representative, or maybe the engineer's assistant. They are representative. So let's say the employer and the contractor sign a contract. And contractor made a biggest mistake. Biggest mistake. The employer and the contractor sign a contract, and the contractor made one of the biggest mistake. Engineer went to the court and filed a case against the contractor. Engineer went to the court and filed a case against the contractor, telling court, the contractor did ABC problem. Because of that, the employer lost huge amount of money. So I want to take legal actions against him. So court will take their case and they will move the case further. Are you all agreeing with me? Are you all agreeing with me? Very good. As I said earlier, the engineer never signed the contract. He's not even a person. He is not even a person who can think about or has a right to change the clauses in the contract. He's not even the person who can think about asking the contractor to do ABC, asking the contractor to plaster a wall. He's not even a person to do, instruct, or maybe direct the contractor unless otherwise the employer asks him to do that. So if he is going to go to the court will ask, who are you? So in the contract, I can see two peoples, the employer and the contractor. Are you an employer? Are you the contractor? No, I'm the representative of the contractor. Please be aside. Don't come and talk to me. Tell those two people to come and file a case if they want. So the court will simply tell you that only the parties who signed the contract, they are the parties who can take the rights, obligations, or any issues, any problem between them, any concern, any fighting, any money give and take, everything between those two parties only. And no third party personnel can be linked or maybe can act on behalf of other parties without permission. So only the contractors and employer. Similar to that, the contractor cannot go to the court and tell that, dear court, engineer did not give me access. So I need to file a case against the engineer. The court will tell that, okay, give you a case. So give you a contract. Who are the signed party? You and the employer. So who is engineer to you? Who is engineer to you? It's nothing. You don't have any contract with the engineer. Why you are filing case against him? The contract say that one, there will be access. The access will be provided by the employer. So the employer is the one who signed that. He must have provided you with an access. If not, you come and file a case against the employer, not against the engineer who is third party to the contract. Many of you, confused about what is third party. The first party, employer. The second party is the contractor who signed that. All other people, third party. Whoever involving with that one, stakeholders, they are third party, subcontractor, supplier, engineer, supervision consultant, cost consultant, ABC, designer, all the peoples are third party. So this contract very clearly say that only these two peoples are agreeing. These two people are agreeing that he will give, he will buy, he will do, he will execute, he will approve, he will do that. And any other third party outside people supporting to complete these two people. So this principle, this legal principle, we call that privity of contract. This legal concept that only the signed party, only the party who signed the contract, only the party who agreed for this contract, they can only sue others. They can sue others, but not any other third party, or the third party without any contract with this, they cannot come and take one person to the court. That's what we call privity of contract. That's what we call privity of contract. So remember, only the employer and the contractor, they can go to the court. I mean, I'm just speaking only about the court, legal actions, yeah, or maybe rights, or maybe obligation. So only these two people can go to the court and file a case against other person, and they cannot link other party. Oh, engineer also handling the contract. He is the contract administrator. No, you cannot tell that. Okay, that's what we call privity of contract. So remember, when they ask about what is privity of contract, or maybe when the engineer say that one, something like we can take you to the court, you can argue with him. You are not privity. You engineer does not have any privity of contract, or he's not the person who can speak about that. Right. And similar to that, when we speak about contracts, in contracts, do you think that you have only one type of terms and condition? All the terms and conditions were agreed by the parties. All the terms and conditions were agreed by the party, so no other terms and conditions can come into the contract. Are you a person with this perspective? Remember, all the terms and conditions in the contract, they are manually writing and agreeing. They're both parties sitting, they do go through that, they do change hundreds of changes throughout the pre-tender stage. They argue and change all the terms and conditions, and they are going to sign that one. That terms and condition, we call that as express term. The meaning of that, both parties expressively agreed. Both parties expressively, exclusively, those two people sat and those two people agreed to write something, and those two people agreed to put some conditions of clauses, and both of them agreed with those two items, those two items, those two clauses, those two execution, whatever it is. Those two people agreed, or maybe 3-4 contractors, whoever the person who is going to sign, if they very expressively agreed certain terms and conditions, I will pay the contractor within 14 days. The contractor will submit the design within 35 days. The contractor will execute the work and complete it within 300 days. All these items are they two are sitting, agreeing and signing that. These terms and conditions we call express term. Very simple example, as I said, the contractor agreed with the employer, I will complete the work within 300 days, or maybe on or before 31st of December. Something then we call expressively, you two agreed on these terms and conditions. And when we speak about contracts, guys, we have another terms called implied terms. There are 4 types of term. I'm not going to go all of them. So the second important terms we're going to see about implied terms. So forget about here, understanding that not only the terms and conditions incorporated within the contracts are the terms and conditions of your contract, but there are some external terms also, and that may be penetrated, inserted into your contracts too. So let's say a very simple example, if you all need to understand. The UK government's law says any contracts that will be executed more than 45 days, any contract that will be signed and executed more than 45 days, they need to have a clause called interim payment application. Similar to that, the UK government say that certain list of contract types, they mentioned that construction contract and many other contracts, all these contracts should have a dispute resolution mechanism called adjudication. They just made a law and left it. Let's say 2 contractors came and they signed a contract for 90 days. And in that contract, they did not include the interim payment. They did not include, but both parties expressively agreed. Yes, I don't want an interim payment. The contractor said, I don't want any interim payment. Let's continue the project and complete it within 90 days. At the end of the 90 days, please pay me. But after 50 days, the contractor got a problem. He got some kind of cash flow problem, cash flow issues. And now he requested the employer to provide some money. The employer said, no, we already expressively, we signed, we agreed. You say that when you don't want money any early, so I did not prepare myself. I don't have money. I will give you money only at the end of the contract sign after contract completion 90 days. Then this person, he will go to the court. The court will check that. And the court will tell, guys, it is our law, our UK, British law, the country's law, that any contract more than 45 days should have the clause related to interim payment. Even though you two expressively agreed not to include that, receive the money after 90 days, as you are not following the government or the country's law, now as a court, I am inserting this clause into your contract and you two need to follow that. You two need to follow that. Even though the contractor and the employer very explicitly agreed, I don't want the interim payment application, interim payment money, the court insisted you. The court implied this term into your contract in accordance with the law and ask you to go and follow that. That's what we call implied terms. There are a couple of other terms like incorporated terms, boilerplate term. We don't want to go detail into that. These are the two major terms and conditions you need to aware about it. So the express terms mean, guys, both parties very expressively agree. When it comes implied term, the parties will receive some clauses and everything from the court, or maybe from the law, or maybe from their customs, their regular custom. For example, some industries, they will tell that, all right, normally we don't delay payment 7 days, even though it's not mentioned in the contract, even though the court did not speak about it, but our habit, our behavior, our custom, our norms, our customs, it says that we don't delay more than 7 days, so we should not delay. Even though you did not expressively write that within your contract, you are considering that as a practice, industrial practice for your project, for your employer, and you are following that. That will also be considered as a terms. So remember, guys, the terms and conditions very expressively written in a contract we call express term. The parties, both parties agreed. But other than that, any other terms through court or through law or maybe through your practice, if that's going to be considered as a terms and condition, those terms and condition, we call that as an implied term. We call that as an implied term. Okay, so we have learned about privity of contract and express and implied term. And the next one, that this is one of the very common words that many of the MRICS personnel they do use. We call Contra proferentem rule. It's a principle of a contract. Let's say I'm an employer. I drafted a contract. I drafted the contract and I gave that to the contractor and I asked the contractor to price it. And at the time of tender, I gave all the drafted contracts and everything to him. And I asked him to price it and he started to price. He started to price. And he checked the contracts and everything. And some places he was unable to understand the terms and condition, but he tried to raise the tender clarification. Employer replied, he was not unable to do that, but he allocated some contingencies or maybe a risk and started and price it. So while they were executing the work, they identify one word or one sentence as a two different opinion. For an example, while I was working for one of the metro project, I don't want to name that. In that project, what happened? In the contract they drafted, okay, you know that when there will be metro, there will be a metro operators, and the metro operators will collect the money from the people as a metro fee. Yeah, they will collect the money, and all those money will be deposited. Or maybe if they are going to swap the card, or maybe pay by notes or coins, there will be small machine. They will put the money. So in the contract, it say that the next day from the collection of the money, if I'm not wrong, or the contractor will deposit the collected money next day, immediate after the collection, to the employer's account. What it says? Immediate after the next day from the collection, they need to deposit to the employer's account. I, as a contractor, read that in a different manner. What did I read? I said, I'm going to collect the money from the contractors, and all the monies will be deposited into the deposit machine, ATM machine, or whatever the machine that we have. I will put the money into that. Or they will swap the card and that will be deposited into that account. So maybe every week, every 2 weeks, I will open the box and collect the money. And immediately after the collection of the money, next day I will deposit that to the employer's account. As you all know that, it's not a simple task of collecting money and transfer the money to the banker. You need to appoint a security, a very specific company. You might have noticed the van, which is going to, which, through which they do transfer the monies and everything, security vans. So you need to hire that. You need to pay huge amount of money. And the contractor calculated, right, for a 5 year, they may pay to the security company roughly around 50 millions. Think about, this is for every week, every week or every other weeks. Think about if I'm the employer and ask the contractor, dear contractor, no. In the contract we mentioned, immediate after the next day from the collection, the meaning of that, from the day of you are collecting from the customers. It's not about depositing the money in the box and open the box after 1 week or 2 weeks and collect the money, and next day, immediate after that, you are depositing. But once you collect that from the customer, you need to immediately deposit the money to us. In this scenario, every day the contractor needs to collect the money and send that with the security card to deposit to the client account. So think about it. Every week or every other weeks, they are going to charge 50 million. Think about every day if you want the security company to come and collect the money, how much it will cost. So this is a very confusing terms the employer wrote. While executing the contract, we identify this as a concern. So we went to the court. Dear court, this is the clause they are telling. We are with a different opinion. We are thinking that once we collect it from the deposit machine, we will deposit that to the client account immediately next day. But the client with an opinion, we are collecting the money from the customers, the passengers. So immediately next day, we need to transfer the money to the client account. So it's a huge difference. When it comes some kind of ambiguities or maybe some kind of difference in opinion, if you go to court, the court will take or will give advantages or will give favor to the person who did not write the contract. Who did not write the contract. Or in other words, the terms and condition, the employer drafted that. That's ambiguous. It's not clear. Because of that, dear employer, I'm going to take a opinion towards a contractor. I will give you less favor. I'm going to give more favor to him because you drafted, and we don't know with what opinion or what mind you drafted. You should have drafted in a very good manner. But as you haven't drafted that, I'm going to consider contractor's opinions most related and good, and I'm going to move toward that. The courts will not act partial, but they will take this stand to ensure that the person who understood at the time of contract may be this way. So I'm going to go with it. This is one of the biggest concern when you draft your contracts or when you review your contract. You must be very aware that you need to read each and every clauses. You must be very much aware about it, and you need to make sure that there are no ambiguities, unclear matter. Okay? What's the purpose of this clause? What's the purpose of this doctrine? To make sure that all the contracts the people's going to sign, all the contracts that the people's going to draft, that will be very much clear. They should not make any mistake, or maybe any these kind of ambiguous. Some employers, they do draft these contracts without making very clear. So later, if any problems come, they can tell, oh, you remember that we drafted like this because of that. They may come and argue with you. So that's the reason they do right. So, but if you identify any ambiguities at the time of tender, before tender, you should raise it to the client and make a clear, clarification, or you must be very much vigilant. If you are a client or consultant contractor, QS, make sure that if you identify any ambiguities, clarify it by telling the parties, guys. If not, at the time of contra proferentem rule, based on contra proferentem rule, we will not receive any benefit. So let's make our terms and conditions clear. That's what we call contra proferentem. And the next one, we have severability clause. Severability clause. In contract, you might have read that some places the employer will mark one clause or mention one clause telling that severability clause. How many of you read these kind of things? How many of you read what is severability clause? Any of you? No. Okay. Anyone else? Yes, I have read. Okay. So what is that, Kuram? What is that clause? What that clause says? If one party is invalid, the rest hold. I have read. Waqas. Okay, tell me what is that clause says? Okay, let me explain. You drafted a contract. In that contract, you made a very small mistake. And you identified that you went to the court because of the clause. And the court said that one, yes, this clause is not correct. This clause was drafted wrongly, and this clause cannot be executed. The contractor will come and make a fight. Oh, employer, you drafted this clause in a very wrong manner, or you did so ABC. That's why I was unable to execute my work properly, and I'm going to stop from my working, and I'm going to terminate the contract. They may come and make these kind of drama to escape from the problems. So that's why the client, in a clever manner, they do include in the contract a very small clause called severability clause, which says, dear contractor, it's not going to be like a letter, but I'm telling that, dear contractor, in any case, in any of our clauses, any clause in the contract, if you or court or anyone identify that that clause is not correct, that clause is not valid, that clause is an invalid clause, then don't come and drama with me that you are not going to follow other clauses. Regardless of that clause, all other balance clauses will be implemented. All other balance clauses will be enforced and will be implemented. Okay? So remember that. You can't tell that one, oh, in the contract, this is very important clause, and the employer made it as a wrong, it's not valid. So because of that, the contract is not valid. Thank you so much. We will terminate it. You cannot tell if you have severability clause in your contract. If you have such a clause, it's a very small clause. They will tell that severability clause. So parties are agreeing that that so-and-so thing happened, any of the clauses within the contract considered as a invalid, all other rest of the contract or terms and condition will remain valid, and that will be considered as enforceable. Enforceable mean that will be forced to do. Okay, that's what we call severability clause. Right. Many of the contract I worked, I have noticed the severability clause, but we never practice that because all the contracts, terms and conditions drafted in a contract in a very careful manner they drafted, and none of the clause we considered, or maybe if the parties concluded this clause is not suitable, or maybe this is an invalid clause, we never consider that. But almost all the contracts we considered and inserted this severability clause in those contracts. So what is the meaning of severability? Even though one clause or one small portion of the contract is not a valid item, all balance item will remain as a valid, and that will be enforceable by court. Okay, right. When it comes entire agreement, it is also similar to other clauses in your contract. In your contract, you might have noticed many documents they do list down. Yeah, order of precedence 1.5. If you take FIDIC, it says that contract agreement. Yeah. Then after that, specification, or maybe the other documents, specifications, B or Q, A, B, C, X, Y, Z, all the document, you will list them down. You do list them down. And some situation, some of the document that you communicated with the employers through email, through letters and everything, even before you sign the contract, through which you might have communicated very important information. But unfortunately, that letter or that email, you did not list that document in your order of precedence. Or maybe any other places, you might have mentioned many documents. This document you failed to mention. For example, one of the airport project which I work. So before signing the contract, what happened? This contractor prepare a very nice value engineering proposal. Huge amount of saving. So he communicated that letter through a letter. He sent that to the employer. The employer, as an offer, we submitted our price of XYZ amount. In addition to that, we prefer to submit these value engineering through this letter. Through this value engineering, we may be able to save hundreds of millions of money. So they listed down all the value engineering and they put how much we can save and what is the alternative item that we are going to go and send that to the employer. They signed the contract, and at the time of signing the contract, they did not include this letter through which they mention that we can do the value engineering and save huge money. They did not include that. In the contract, they did not include that letter. So they executed the contract. The contract came to the place where the contractor wished to execute the value engineering that he proposed at the time of tender. So he requested the employer, I provided many value engineering. I want to do that one. The employer issued an engineer instruction. On one simple example, we want to convert the concrete column into steel column, which will provide us, let's say 100 million or 10 million or 8 millions. Okay, some of the concrete column original design, the contractor wants to convert them into steel. They receive an engineer instruction where it says that, yes, please proceed this one. The contractor is very happy. He saw that, all right, you see, they instructed us to do this work. So I'm going to save and receive huge amount of money. They submitted value engineering. Value engineering, we all know that it's a systematic approach of delivering the functionality or maybe the required work without impacting the function with a reduced cost. So we all know that one FIDIC says that if the employer is going to execute any value engineering 13.2, The contractor will receive portion of saving. Portion of saving. So this contractor received an engineer instruction. He thought that one, oh, I'm very happy because this conversion of the steel column to concrete column will give us at least 20 million. So I can receive 10 million saving. I'm going to save 20 million because of this conversion. So as per the contract, I'm going to receive 50 million, 50%, 10 million. They started the work and they requested the employer, as we have executed XYZ value engineering, please pay us the saving of 10.23 million as we have submitted previously. The client replied, dear contractor, thank you so much. But where we have inserted or where we have mentioned that this value engineering or the letter that you sent to us is your contractual document. He replied, you communicated with us about many things. You wrote many emails. You issued many letters. You communicated many things and many other things that you provided. We never considered those documents as your contractual document. In addition to that, in our contract, you as a contractor and we as an employer, very expressively agreed and inserted one clause called entire agreement clause. What they said? Entire agreement clause. While I was learning my LLM, I learned that we went through many case laws. Yeah, the court, how they have awarded the problems, how they have resolved the problem. And I noticed one very important about this clause. If this clause is already incorporated into a contract and both parties very expressively agreed, yes, I'm 100% sure only the listed item or only the document mentioned within this contract are the contractual document. Not any other documents will be considered as a contract document. But these two parties are writing this clause, entire agreement clause, telling this. We will not consider any document outside the document listed within this contract. So if those two parties sign, even the court fears to interfere into that, because it's very clearly both parties, both of them agreed that I don't care about any other document. Only these documents are the contractual document. Then how you contractor can come to the court and tell that, oh dear court, you know that when I provided this letter, in that one I mentioned, but even though we did not include that within the contract, please consider that letter and provide some money. The court will ask, in your contract, you very clearly mentioned these 5 items or 20 items, 25 documents are the contract document. Not a single outside document will be considered as a contract. So on what basis you are coming and arguing with me? I notice many of the cases, the judges and other people, they were very much reluctant to take actions against that clause. Even the many courts, many judges, they very explicitly mentioned that this is one of the dangerous clause in the contract. If you have such a clause, if you are a person who is working in the tenders or something, if you receive these kind of clauses, ensure that you are going to include all the verbal promises, all the letter, all the important email communication, any other document as your contractual document. And one of the contract which I am managing now, DCP, district cooling plant, which I managed district cooling plant. In that contract, a contractor is very smart. What happened? They agreed the particular condition, they agreed the condition, they agreed all other things and everything. And even before they signed this contract, the contractor issued an email about advance payment release and the authority approval, permission to the building, so on. So I think a couple of items. And they requested the client to reply to those things. And they brought that email and inserted that email within our residence order. They say that one, this contract forms using ABC, XYZ, MN or PQR documents. In that, they inserted this email also. So we requested the contractor, dear contractor, you need to go and get a FLS approval, go to the civil defense and get an approval. The contractor replied, dear Muhammad, as you are aware, our email communication with the employer before signing the contract also a contractual document. Because why? They inserted this document. As this is a contractual document. In that document, in that email, the client very clearly agreed, we as a DCP contractor will not interfere or will not go for a permission from the authority. However, we will give our support to mall contractor. So you see how clever they are. They did some communication through an email. They brought that and inserted within the contractual document list. So when it comes entire agreement, if you have something, the meaning of that, the parties explicitly states that only the written contract documents, only the document inserted with this, only the document linked and very specifically mentioned are the contractual document. Any previous prior discussion, verbal discussion, communication, letter, email, phone call, minutes of meeting, nothing will be considered as a contract. So you must be very careful. When you as a contractor, when you sign a contract, you need to read whether in your contract do you have an entire agreement clause. If so, ensure that you are going to tell your management, dear management, we have a very serious concern that this clause is a very, very, very dangerous clause. So we need to make sure that whatever the document that we want to include within a contract, we need to list them down. It can be 770, 700. But make sure you are going to list them down, any important documents that you want to include. That can be letter, that can be email, that can be WhatsApp, whatever it is. Okay? So remember that this is what we call entire agreement in a contract. I hope you're not sleeping. Yeah, you all are with me. And I don't think that you are drifting away from me. Yeah. So I just want to ask a very simple question. How many of you have actually read a contract recently? And what is the most surprising clause that you notice? You read your contract and you're surprised because the parties agreed, because parties agreed these kind of terms and conditions. What is that clause? Tell me, what is that clause? Just type the clause name, that's fine. Okay, Mervin mentioned that determination clause. Okay. Payment terms. Okay. Bobby can say that one, payment terms. I want to hear some weird clause or weird something that you notice in your contract. No cost entitlement is given in the event of fossil. Mofrit, okay, novation. Imran Musa Corporation. Mohammed Jamsid, right to vary, amendment or omission. No entitlement for delay payment. No exclusion clause was there. Yes, I read. No any priority. No any priority document. Okay, that's impressive. Yes, I read the particular clause. No escalation in the project. No constraint on rule of contra proferentem. Okay, Jilani. Omission without compensation. That's very common. No ADR, direct litigation. That's also common. Payment clause deleted from the contract except advance payment. Oh, really? Okay. Employer reserve the right to omit 100% of the work and award to another contractor. Okay, award to another contractor is understandable. 100% is very rare, I would say, but still people are practicing that. LD is excessive. LEG 36, I don't know what. Within 28 days, intimations of variation, time of essence, employer can descope any item, termination, no arbitration, delete, price escalation, EOT clause removed, no provisional sum was kept in the contract. Okay. I'll tell you one of the weird clause that I encountered. Okay. In the contract, the parties agreed. The employer can descope the work. If the employer is going to descope that, then the contractor will be paid with 9.9% of the overhead and profit. 9%, 9.9% of the total overhead of the profit. However, the employer add one more sentence. However, if our total contract amount not changed to the agreed contract amount, then the contractor is entitled for zero overhead and profit. So the employer said, we will pay you. If we are going to descope the work, we will pay you the overhead and profit 9.9% or 9%. However, we omitted something, but we gave other works, variations and everything. Overall, if that amount, total amount is still the contract amount or more than the contract amount, we will not give you any omission 9%. So it's really, I never practice such a thing. So they say that one, okay, if we omit, we will not give you, or if we omit, we will give you. If we omit, we will give you. But at the time of omission, if the total contract amount is more than the contract amount, original contract amount, or equal to contract amount, we will not give you a single penny. Okay. So remember, guys, reading a contract is an art. At least you want to know these fundamental elements to tackle the things in your meeting. Okay. Right. As a continuation to some of the principles that we learned, the next one that we're going to learn about what is offer, what is acceptance, and what is intention. Okay. In the construction industry, who is the one who is offering the work? Who is the one offering the work, or I would say, okay, contract. In the construction industry, who is the person, whether the employer or the contractor, who offers? Of course, contractor, client, contractor, employer, contractor, employer, employer, contractor. Good. So mixed answers, right? Let me tell you the fact. The fact is, the contractor is the one who is offering. The employer only invite the bidders. We can call that as a treatment. Yeah, he's inviting the bidders and telling the guys, I need to construct a house. So I want your proposals. Please provide your offers. If your proposals are good and within my budget, I can give the contract to you. So the contractor will go back and start to work out and prepare a good proposal. And in that one, they are going to tell that, dear contractor, I'm offering you to complete this work for a 300 million. Another contractor, I will complete this work within 280 million. Another contractor, I will complete this work 310 million. And all these people are offering their likely to be incur the cost, and they are telling that this is my offer. If you want me to complete this project, or if you are going to give me 300 million, I will complete the project. If you are going to give me 280 million, I will complete the project. The employer simply reject couple of people. You can say, oh, 320, 300, I don't want. I'm going to go with 280. Right? I'm going to go with 280. Think about other way around. If the employer is the offer, he is the one who is going to offer something. All the contractor will come and accept it. Yes, yes, thank you so much. I'm accepting. Give me the work. I'm going to go and do that. That's not going to happen. Always, the client will invite them to treat them. They will come to the plate. The client will put the request to them, and they will study the request, and they will offer to complete your building as you want. I'm offering 300 million. And remember that when we speak about offer, that offer should be accepted unequivocal. That should be accepted without counter argument, without counter argument, counter request. So then let's say I'm a contractor. I offer to construct and complete the building for 100 million. The employer say that one, no, I can give you 90 million. Will you complete my house? The contractor will tell, thank you so much. Then employer said, oh, okay. Come and do that for 100 million. He will tell, no, I offered something. You objected. You made a counter offer. Then finish. The offer should have an acceptance, and that acceptance should be unequivocal acceptance without any other condition that should be accepted. That's what we call offer. So if the employer is going to go to the court and tell that, oh dear court, you see this person offered 100 million, then I asked him to come and do that, but he is now refusing to do. Court will ask the contractor. Contractor will tell, dear court, I offered him 100 million. He counter offered. He said that one he requested me to come and do that for 90 million. I said, no, done. Then second time he asked me to come and do that 100 million. I said, no, now my price is 120 million. Yeah. So when we speak about offer, the offer should be accepted without any counter offer. That's what we call or maybe counter element with that. Any supporting element, you need to accept as it is. That's what we call unequivocal acceptance. And when we speak about this offer and acceptance, guys, there should be an intention. Let's say I found my friend's car as one of the fantastic cars. Okay, I found that as one of the fantastic cars, very nice. So he took me a ride and I enjoyed the car, and I came back home and I wrote a message for WhatsApp or maybe a letter. I wrote a letter and said, my friend Muhammad, I loved your car and I enjoyed your ride today. And I'm offering you 700,000 or maybe 200,000 or whatever the amount, 100,000 to buy your car. Please reply me within 7 days. If you are not going to reply, I will consider that you are accepting my offer to sell your car for 100,000 or whatever the amount. Okay. So after 7 days, what will happen? After 7 days, what may occur? What may happen? The person who wrote a letter, he will come and grab the key from him and he will drive the car. Am I right? Okay, then what will happen? Think about the scenario. If this is the situation, I can write, all the peoples, I can write the king. Dear king, I like to become a king. If you are not going to reply to me within 2 days, I will consider that you appointed me as a king. Yeah, how lovely. Think about a scenario. So when we speak about a contract, the contract should have an offer. Someone should offer that. Another person should accept it. And also that person should have an intention. So the scenario, the example which I said earlier, where the friend who gave you ride, he never thought about selling his car. And even in the dream, he said that I'm going to sell the car. But you came and you imagined, you wanted to buy, and you wrote a letter and you made a condition. You are the one who is going to execute that? No way. So when we speak about contract, someone should offer it, someone should accept it, and of course, those two parties, or maybe whatever the party is going to involve, they should have an intention. They should have an intention. The main reason of this rule, to demonstrate and to make sure that the parties are coming into an agreement within the legal relationship with a mind, with an intention, with a proper understanding about what they are executing. So remember that I can't write a letter and tell my friend, I'm taking your car if you are not going to reply to me. He may think that, what a funny guy. I never told him that I want to sell my car. Oh, I don't have an intention to tell my car. So how come that he can come and take it? Yeah. So that's a complete scenario where we need to make sure that someone should offer it and the opposite person should accept it, and both of them should have intention. There are many simple factors like this: offer, acceptance, intentions, and everything, guys. We are not going to go very detailed into that. If you are an RICS candidate or something, you may deal and learn each and every factors in a detailed manner. And the next important, fourth important items that each and every contract should have, we call consideration. What is consideration? Without that, in common law, the law that's being practiced in British or UK and a couple of other countries like US, Australia, and a couple of England and New Zealand, and some other countries mix use law. It's a common law mean. I don't want to dive into that common law, civil law, Sharia law, and there are a couple of other laws. We don't want to dive into that, right? Common law mean the laws introduced by the judges, courts, and that will be continuously followed. All the rules and everything made by court will be continuously followed, right? So when we speak about consideration, there should be a value of output. There should be a value of output between both parties, or three parties, or five parties, whoever they are involving. The party should receive some value as an exchange to the things that they are going to offer, right? So I offered to execute the work for 300 million. I will do and complete the work and give that to you, and you need to pay me 300 million. So when you take this scenario, employer and the contractor, the employer will receive the completed project as a contractual outcome, where the contractor will receive 300 million as a contractual outcome. When these two people receive the requested value of their contract, or the agreed value of their contract, we call that is their consideration of that project. In RICS APC, they do ask this question: what is consideration in a contract? It's a very simple, straightforward answer. You're going to tell that it's something of value exchanged between the parties. For example, the contractor is going to receive money as an exchange for the work that they are going to execute. For the work that they are going to execute. That's what we call value exchange. Okay? Remember that. So consideration means offer, acceptance, intention, and they need to have consideration. That's something will be exchanged between the parties for the work or the execution or the things that they are doing. And in GCC, is consideration compulsory? No. In GCC, most of the countries, they said, we need lawful cause and intention. We don't think that consideration is must. Outcome, exchange of the benefit is not must in GCC. But in most of the other countries, yes, if there is a contract, this person should receive benefit and this person also should have received benefit. But in GCC, that's not compulsory. Most of the jurisdictions says only intention and cause is enough. We don't want the consideration. Okay. For example, let's say I'm a believer. Okay, my friend came to me and said that one, asked me, I need to value my building. Can you please value that? I'm going to tell him, yes, I will value that. But for future problem and everything, I want you to sign a contract. Zero money, no money, but sign the contract. Because I'm going to give you some advice. Based on the advice, if you are going to execute any work, maybe later you may come and tell that, oh, you see, court, my friend asked me, he made some valuation based on that I sold my property. And now I got to know that my property is more than the value. So he wrongly directed me. Even though I did this work for free of charge, he may take me to the court. To avoid that, you need to have a contract. But there are no requirement to have consideration. I'm receiving zero money. There are no requirement to have consideration. But common laws in other countries saying that, yes, if it is a contract, it is an essential factor to have consideration. Okay? So remember that. That's what we call consideration. And the next one, duress and undue influence. We call it as anyone else can bring the any other name. Anyone else? Undue influence. Without any third party. You know, someone can prepare a contract very nicely. Everything I'm offering, he's accepting. These are the output. And someone can place a gun and say that one signed the contract. You mentioned everything. I'm selling my house for 2 million to ABC personnel. Yeah. You don't want to sell that. You don't prefer to sell it for 2 million. It's worth of 20 million, but someone pointing gun at you and asking you to sign it, you signed it. Later, you identify that it's a mistake you should not have done. So you went to the court and mentioned the court. Dear court, of course, you can see that contract. It's a valid contract. Offer, acceptance is there. I offer that and he accepted. And that's for the 2 million amount of money. And there is so and so thing, everything. But the problem, I was forced to sign that. In one of the country, I don't want to name that, the government and governmental influential peoples, they force the people to sell many properties for very nominal value. Very minimal nominal values. Let's say 20 million worth of building, they sold that for 200,000. How? The contract is valid. Offer is there, acceptance is there, intention is there. The people are legal capacity people, so they sign it. But how they sign it? Under pressure. They say that one, no, you need to sign it, you need to sell it, otherwise we will kill you or we will destroy you, so on something. So when we speak about contract, the contract will become valid if the parties executed the work with the proper freedom. There shouldn't be any other third party people involving or forcing the person to sign the contract. If they say that, then the court can check the entire scenario. They will investigate it and they can cancel that contract. They can cancel that contract. Okay, we call that as a genuine consent. Genuine consent. So I don't have any other free or third party people, pointing gun at me, asking me to sign. I signed with my free mind without any third party pressure. That's what we call duress and undue influence, or maybe we call genuine consent. Okay, I'm signing and agreeing this agreement or the contract with the proper mind without any third party's involvement. That's what we call duress and undue influence. So remember that if someone asks you to sign a contract with, he forced you to do that, then you can later go to the court. Everything becomes normal. You can go to the court and the court will ask you to cancel the contract. And the court will take legal action against the person who forced. Yeah, you might have heard many stories, right? Politicians or maybe big top, influential peoples, they do, threat the people to sign and sell their properties. They sold that for very nominal value. And then I don't want to mention the country. Many countries it occurred. Okay, so that's what we call genuine consent. And similar to that, the next one, LD, liquidated damage versus penalties, right? How many of you have noticed in your contract you have liquidated damage? Nakmal. Okay. Liquidated damage. Okay. Right. So in a simple manner, guys, I want to explain you one thing. Okay. Liquidated damage, we call it as a genuine, predetermined, actual loss. Let's say I'm constructing a hotel. I'm constructing a hotel. And I agreed with the contractor, dear contractor, you need to complete my hotel or no before 31st of December. If not, every day I may lose my rental. So I plan to open my hotel from the 1st of January. And from my program, I anticipated every day from the very first day, 10 rooms, second day, 20 rooms, third day, 30 rooms. I have 500 rooms, for an example. So for a 2 or 3 months period, my rooms may, this amount of, escalated. This will be escalated to this level. So I may earn this amount of money. Okay. So I guess that amount of money I predetermined the actual loss may occur. And I'm going to insert in the contract, tell the contractor, dear contractor, you need to complete my project 31st of December. If not, every day, first day, I will lose my 10 rooms rental. That's going to be 20,000 riyal. The second day, I'm forecasting that I may lose 23,000. So the second day, I will furnish you, I will back charge you 23,000. So I'm going to agree with the contractor a terms called liquidated damage. Liquidated damage means genuine, predetermined. Earlier, I'm going to determine that the actual loss of my work. That's what we call liquidated damage. In some contracts, you might have noticed penalties. You might have noticed penalties. The meaning of penalties, it's not a genuine actual loss. It's not a genuine actual loss, but it's an amount of money, unreasonable amount of money. Previously, I said how much? The employer gonna calculate first day how many rooms I may lose, the second day how many rooms rental I may lose, third day, fourth day, something like that. They will calculate actually how much I may lose. When it comes to penalty, the clients will not going to give you the actual amount of money. In the contract, he will mention that, dear contractor, if you delay my project one day, the first day 100 million, the second day 100 million, the third day 100 million. Both parties agreed, done. It's not a predetermined, genuine, estimated, predetermined amount, but it's just an unreasonable, not a reason to tell that why you put 100 million first day. Oh, I don't have any reason. I just put 100 million. And also I mentioned that it's a penalty. I did not mention it's a liquidated damage, genuine, pre-estimated actual amount. I did not mention that. I use a word called penalty. Okay. Remember, if they have mentioned penalties in your contract, you must be very much aware about it. If it is penalty, you cannot go to the court and argue the court like liquidated damage. When it comes liquidated damage, in the GCC region, the court will check it and the court can prove. If the court can prove, yes, you mentioned your liquidated damage for a first day 20,000 real, second day 23, fourth day 25, fifth day so and so thing. But we check that for your hotel, the first day there wouldn't be 20,000 rental, that's going to be 3,000 real. The second day maybe 3,700. Fourth day so and so. The court will determine, can check and change the liquidated damage if the contractor challenged you. You mentioned the name is liquidated damage, actual predetermined actual loss. So the contractor can go and tell the court, dear court, it is not his actual loss, but he is charging me unfairly. The court is to resolve the problem. And they will not allow unfair so and so thing. So they will call that and they will investigate. If they identify that, of course, they can force you to stick with the number the court going to give you. But if you are mentioned in a contract that amount as a penalty, you and the employer expressively agreed, right? Okay, if I delay 1 day, okay, I'll pay you penalty. Then the court will not challenge that. The court will tell you both parties agreed to pay 20,000 as a penalty. So I have nothing to do with that. But if the employer mentioned that as a liquidated damage, then I will check it. Whether he mentioned truth or maybe his amounts are right or wrong. Is that an actual loss and everything? I will check it. So when it comes liquidated damage, and today also I was questioned by the client about the liquidated damage. So I'm telling you, the liquidated damage is one of the biggest item or biggest number or biggest element that you need to pay attention. In your contract, if you have milestone, and against the milestone, if you have any liquidated damages, you need to be very carefully, sharply adjust that number. Okay? If not, you will be end up paying that. And very importantly, if that amount they mentioned not liquidated damage but a penalty, then of course it's compulsory for you to sit down and agree with the employer to a very, very good amount of money. He put 1 million, don't agree that. Make it to 10,000, 20,000, 50,000. Okay? Why? You cannot go to the court and challenge that number if it is a penalty. If it is liquidated damage, you may go to the court and challenge it, and the court can change that amount of money. Okay? So remember that. It's a liquidated damage mean it's a genuine, predetermined, actual loss. Okay, how much he is going to lose actually. That's what we call predetermined liquidated damage. Okay, this is one of the elements that you need to pay attention about your contract. And the next one, good faith obligation. Good faith obligation. When we speak about these terms, guys, we very often use this term. Oh, right. In good faith, the engineer approved that. In good faith, we did the work. In good faith, we executed the work. What is this good faith? In a simple term, the good faith means it's a duty of the parties to act honestly and in a very neutral or fair manner. The parties, activities, execution, agreement, the discussions, everything should be honest and fair. That's what we call good faith. Okay, good faith means the contractor or the employer acting in a very honest manner. Dear contractor, yes, in a honest manner, you are entitled for the DOT, take it. The contractor, the employer, in a honest manner, yes, that's my mistake, so I will accelerate and complete the project. That's what we call good faith. But when it comes common law, the law like English law, or maybe Australian law, or American law, or maybe some countries which are practicing the common law, they are very much reluctant to consider this word called good faith, because this word can be interpreted in any way that they want. The contractor can come and tell that, yeah, the way that I did, that is the honest and fair manner. He can argue. The employer may argue, no, that's not the fair and honest manner. In my perspective, this is what honest and fair manner. This is what honest and fair manner. So it's a broad explanations available for a good and good faith. It's with a broader explanations when it comes good faith. That's why most of the common laws countries, they don't want to enforce the people to follow good faith. But when it comes GCC civil codes, like Saudi Arabia and all other countries in the GCC, most of the countries, they explicitly, very importantly, they are telling the people to follow good faith. Even if you take Sharia law of Saudi Arabia, it says the contract will be executed in good faith. It very explicitly says. Okay. So good faith means executing the duties and act in all situation with honest and fair manner. And make sure that we are going to enforce the parties to do the things in a fair and honest manner. That's what we call good faith. You might have noticed many of your engineers or other people's notice letters and everything. They might have mentioned that. So we, the contractor, in a good faith and best industrial practice, we executed XYZ. Hence, the employer should not consider, or the contractor should not consider, this is their contractual entitlement, or the employer or the engineer should not consider this is the contractor's contractual obligation. So something in a honest manner, we identify something we need to do, so we did that. So don't come and tell that it's your contractual obligation, so you did that, there's a mistake, go and correct it. Of course, we will do that. When you are working for a client, you will do that, but it should not be forcing you to do something. That's why many of the contractual letters, or most of the contractual letters, we try to avoid good faith. But in GCC, you can use it, or maybe I would say that the laws are enforcing you to use that. So you can use that to tell the parties, whoever signed the contract, should act in all situations honest and fair. So you can explicitly mention that. Okay. Right, that's all. I have many things to lecture to you all, but unfortunately, time will not permit us. If it is our RICS lectures, it will go until 10 o'clock. But unfortunately, we have very limited time. Some people requested to make this one 2 session. We'll see, inshallah, next time if possible. Okay. Right. With that all, guys, if you want a CPD certificate, please make sure that you are going to scan the QR code and you're going to apply, put your names and everything. So the admin team will deliver to you the CPD certificate. All right, it's almost 9 o'clock, guys. So I don't want to take much of your times. Let me try to pick a couple of important questions so I can move from that point.